Hello, everybody, and welcome to History/Law Bite number 138, dated December 22nd, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Prigg versus Pennsylvania, 41 U.S. 539, 1842. Prigg versus Pennsylvania was a landmark U.S. Supreme Court decision that dealt directly with the institution of slavery and states' rights. It was a very controversial decision in its time and remains one to this very day. The Prigg decision has been debated by legal scholars since it was issued over its constitutional accuracy. So what happened precisely in Prigg versus Pennsylvania? Well, in this case, a black woman named Margaret Morgan moved from Maryland to Pennsylvania. Although technically a slave, her master granted her such a degree of autonomy that she effectively lived as a free woman, okay? But he never formally emancipated her. To free a slave was a required process to formally free one. It wasn't just saying you're free, go on about your business. No, it was, a formal process that took usually a certain form as well as a notarization, an affidavit or some kind. It varied from state to state, but Mr. Ashmore never formally freed Margaret, and with his death, his heirs, sought to recapture her, and that's exactly what was done, all right? They hired a bounty hunter, all right, named Mr. Edward Prigg to cross into Pennsylvania to see if they could find Margaret, which he was able to do. And not only did he capture Margaret, but he also captured her children, okay? Mr. Morgan himself would find himself captured and arraigned in violation of Pennsylvania's 1826 state law, which forbade the kidnapping of blacks from the state for the purposes of taking them into slavery, okay? Mr. Prigg was convicted in the Pennsylvania courts, and he appealed his case up and throughout all the way to the Supreme Court of the United States. His lawyers argued at the U.S. Supreme Court that the Pennsylvania law was unconstitutional, holding first that it violated Article 4, Section 2 of the Constitution, which specifically allowed slaveholders to receive their runaway slaves if they should run into another state, running into a free state technically did not discharge them from their service, to a master in another state. And they also asserted that the Pennsylvania law violated the Fugitive Slave Act of 1793, That being said, the Supreme Court of the United States, in deciding this question, ruled via Justice Joseph Story that the Pennsylvania law in question, the law of 1826, did indeed violate Article 4, Section 2 of the U.S. Constitution, protecting the right of slaveholders to capture their fugitive slave property. Article 4, Section 2, Clause 3 reads as follows: No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. So the court ruled that Pennsylvania law not only violated Article 4, Section 2, Clause 3 of the U.S. Constitution, but it also ruled that the Pennsylvania law violated the Fugitive Slave Act of 1793. Those things being said, we're looking like it's disastrous now for the runaway slaves, right? But not yet. We're not finished. The court also ruled in Prigg versus Pennsylvania that while the states could not inhibit the enforcement of federal law and the Constitution, they were also not required to use their resources to enforce federal law here. Okay, did you get that? You want me to say it again? Cool. The court ruled that although it was illegal, in this case for Pennsylvania, to obstruct the enforcement of the Fugitive Slave Act of 1793, which was passed to enforce Article 4, Section 2, Clause 3 of the Constitution, although it was illegal for Pennsylvania to obstruct the enforcement of federal law, Pennsylvania, and none of the states, as a matter of fact, with that, were required to use their resources to enforce federal law. Okay? It was up to federal agents, federal government, to enforce its own laws. All right? The states were not required to enforce federal law. All right? This is known from this case as the anti-commandeering doctrine. Federal government, theoretically anyway, in this case especially, was not permitted in any way to force the states to use their resources to enforce a federal law. Okay? So essentially, the conclusion you're getting from Prigg versus Pennsylvania is Pennsylvania lost on all counts, but a small bone, depending on how you look at it, was thrown to the states, more so to the northern free states, that although they were not allowed to inhibit or obstruct the enforcement of federal law, in this case the Fugitive Slave Act of 1793, they also were not bound by the Constitution to use their resources to enforce it. Okay? So essentially, that in mind, federal government was on its own with respect to enforcing federal law. Okay? Keep in mind, though, stipulations may vary in the current era as the federal government has got its hands in much more than you can comprehend these days. But keep in mind the context of this decision. This is 1842. Okay, the country was very much still, very, very confused on just to the extent of true federal power. All right, the Supreme Court was still in the process of defining the true and actual reaches and limits of federal power. And in this case, is very important because they basically told the federal government, all right, that the enforcement of your laws is on you. You cannot force the states to enforce your laws, okay? While they're not allowed to inhibit the enforcement of your laws, okay, via the Supremacy Clause, okay, they also are not required to use their resources to enforce it, okay? It's your law. It's a higher law, of course, because it's a federal law. And per the Supremacy Clause, it trumps any state laws to the contrary. That's why Pennsylvania's law was ruled unconstitutional. But the states do not have to use their resources to enforce it. That is what the court said. Federal government, totally ball is in your court to enforce your law. You can't force the states to do it. All right? So basically, slave masters under this decision, theoretically anyway, were still permitted to come into free states to look for slaves as long as they did not breach the peace in doing so. All right? And thus, from the Prigg decision, states obviously, it was made clear to them they did not use their resources to enforce federal law. All right? So most of them, effectively made it a crime to in any way assist, okay, bounty hunters coming into their states looking for fugitive slaves, okay, absolutely prohibited their policemen and any other officials from aiding slave catchers, coming to look for fugitives in their states, all right? And because of Prigg versus Pennsylvania, you see a litany of new laws being enacted known as personal liberty laws. And those laws encourage citizens to do whatever they could to aid, okay, fugitives. Like I said, it also forbade state officials from helping slave catchers, okay? So you see a whole lot, okay, of back and forth and defiance, okay? Even though the attitude among many was ambivalent to runaway slaves, lots of states, okay, did a whole lot of positive good to help runaways, okay? They're not supposed to be inhibiting the enforcement of federal law, okay? But they had every right to make it a crime for their officials to help in the enforcement of federal law, and they did, okay? They didn't allow their citizens to help in the enforcement of it either, punishable by jail time sometimes, all right? So the federal government was on its own in enforcing the Fugitive Slave Act. Slave hunters could come in the states and look for them, but the people of the states and state officials in the North were often prohibited by law from helping them, okay? So that is what you get from Prigg versus Pennsylvania. In sum, one more time, Pennsylvania's law was unconstitutional because it violated Article 4, Section 2, Clause 3 of the U.S. Constitution, all right? And it also violated the Fugitive Slave Act of 1793. But while Pennsylvania was not allowed to obstruct the enforcement of federal law, in this case, the Fugitive Slave Act of 1793, Pennsylvania, and no other state, in fact, was required to use its resources for the enforcement of federal law in their states. All right? That was up to the federal government, federal agents to enforce federal law, okay? And those pursuing runaways in those states were still able to do so as long as they did not breach the peace. State officials, however, in most places were not allowed to help them in any way, shape, or form. So that, folks, is Prigg versus Pennsylvania. All right. And once again, the citation is 41 U.S. 539, 1842. Thank you so much for listening to this History/Law Bite. I hope you learned a thing or two from it. If you have not subscribed to my YouTube page, I humbly request that you do so. Just hit that little red subscribe button and that little bell, and we are in business. Thanks again for listening. Stay safe out there, and I'll talk to you at the next bite. Peace.